that we're going to talk about to you. So our course agenda today, the Families First Coronavirus Response Act, we're going to talk about first. That was the first piece of legislation the federal government passed that everyone sort of, noted and paid attention to in the employment realm. That covers the emergency paid sick leave, the emergency FMLA. We're also going to talk about the regular FMLA a little bit and the serious health condition qualifications under that, because we don't want everyone to forget about those issues. And we're going to talk about reasonable accommodation leave under the Americans with Disabilities Act. We're going to talk about wage and hour concerns because those issues are coming up. Amy's going to talk about furloughs, layoffs, terminations, and unemployment benefits. We're going to discuss policies. It's important that you have policies. If you all are FMLA employers, if you're a covered employer, you likely have an FMLA policy, and the federal government has updated the FMLA. We're going to need to update that policy somehow with some sort of addendum that lasts this year while the legislation's in play. So we're going to talk about policies you might need. We're going to talk about your illness policies, and we're going to talk about remote work policies. We're going to talk about what an employer can do or say in the workplace, those legal inquiries we can make. We want to make sure we're not asking too much. This isn't a free-for-all to violate all the, HIPAA and other protections out there, but we also want to make sure that we're protecting our workforce. And we're going to talk about when to send an employee home. Then we're going to wrap up with what to do when an employee tests positive. We've both been through that with employers at this point, so we can tell you a little bit of what we've learned through that process. We'll talk about the legal and necessary actions that you're going to need to take if it happens to you. And also, Jill, if you have questions, make sure you pose those to Jill. Amy and I are happy to answer them throughout. This is a little bit different for us. This is the first time I'm presenting over Zoom. I don't know if Amy's ever done it before. She has a background in broadcast journalism, so she'll probably be a little bit more versed in it, but we'll all get through it together. I just want to make sure that we get the information you all want. So with that, we'll kick off to the two protected leaves. We have the emergency paid sick leave and the Emergency Expanded Family Medical Leave Act, or the FMLA. And the emergency paid sick leave, thanks, Jill. Okay, so this is, when you hear emergency paid sick leave, what that is it's the 2 weeks or 80 hours of paid leave that you keep hearing about. So who's eligible? Employers with less than 500 employees are all required to follow this act and provide these benefits. However, if you have less than 50 employees, you may be exempt, and we'll talk about that. So what the benefit is, it provides full-time employees with 80 hours of paid leave, and it provides part-time employees with the equivalent hours of 2 weeks of paid leave. So the law talks more the literature, I guess, the literature or the reports you hear on the news, they talk about 2 weeks of paid leave. The law is pretty clear, it's 80 hours. So you just want to make sure you're calculating it that way and it's not above the 80 hours. If you have employees that work longer work weeks, you may give them, that benefit. If you have someone, an example that's come up quite a bit is firefighters. Firefighters regularly work weeks that are much longer than 80 hours. So if you have an employee like that, you might give them more of the benefit, but it's not going to be counted as emergency paid sick leave. And what that means for you all is you're not going to have that tax benefit over the 80 hours. So you have to be paid sick leave, and we're going to talk about that. And depending on the criteria for emergency paid sick leave, you'll either receive 100% of your pay or 2/3 of your pay. And just to touch on those criteria real quick before we get into it so that you know, the 6 criteria are that you would be on a quarantine through an official order from Department of Public Health, federal, state, local level quarantine. The second would be that you're quarantined because of a order or requirement of a healthcare provider. The third would be that you're seeking a diagnosis because you're showing COVID-19 symptoms. So this would be that you're trying to get a test or something to that nature. Fourth would be that you're caring for someone who has a quarantine, whether it's the healthcare provider quarantine or a federal, state, local quarantine. The fifth would be that you are caring for a child of your own that has daycare or school closure issues. And the sixth is that the Department of Labor issued additional qualifications, and that hasn't happened yet. It's the Department of Labor, the Secretary of Health and Human Services, it's specific groups. So those are the 6 qualifications. At this point, we really only practically have 5 because the 6th one hasn't occurred yet. For those qualifications that refer to your own illness, you're seeking a diagnosis, you are on quarantine, your healthcare provider put you on self-isolation. For those, the employee will be entitled to full pay. For the others, where you're taking care of someone else, whether it's a daycare school closure issue or a quarantine issue, those are where you get 2/3 pay. And that's just how I remember it. If it's you, full pay. Someone else, 2/3 pay. Okay, so then the Emergency Expanded Family Medical Leave Act. This is an extension of the Family Medical Leave Act that we're all familiar with and used to, although here the eligibility is less than 500 employees again, but employers less than 50 may be exempt. This is different than regular FMLA, where generally it's employers over 50 are covered employers. So this is 12 weeks like normal FMLA would be. It provides 12 weeks of protected leave for employees. It provides for full-time and part-time, but I think where everyone is getting confused with this particular law is this only applies in those situations where the employee needs leave to care for their son or daughter whose school or place of care has been closed or is unavailable due to COVID-19. So employees who are diagnosed with COVID-19 or caring for someone with COVID-19, seeking a test or on quarantine, they don't qualify for FMLA under this qualification. They may qualify for FMLA under regular FMLA, but this only is related to school and daycare closures. This FMLA, it's paid at 2/3, similar to what the emergency paid sick leave would be for that same issue. So if we slide through to the next one, I've got some of the questions that have continually come up. And I'm going to run these out of order just so that we can, because it'll segue nicer, to be honest. But how do these two laws work together? So the emergency paid sick leave and the emergency FMLA work together because emergency paid sick leave is 2 weeks, 2/3 paid leave for a daycare school closure issue, okay? FMLA is 12 weeks. But if you read into the specifics of the law, the first 2 weeks are unpaid. So you would run your emergency paid sick leave concurrent with your emergency FMLA and get those 2 weeks paid, and then your remaining 10 weeks would be paid at 2/3. That's how we get there. That's how you show the work. The short story is both of these laws are going to apply, and you're going to have 12 weeks pay for employees, emergency paid sick leave and the EFMLA, and it'll be paid at 2/3. The only time that wouldn't happen is if they've already used their emergency paid sick leave for something else. Okay, so small business exception. I just wanted to go over this because it's more than you just have less than 50 employees, and I think that's important to remember. So you would have to have fewer than 50 employees, and then you'd have to meet one of 3 criteria, and that would have to be documented by an authorized officer in your business. And this would only apply, it only would exempt you from the child care school closure issues per the latest guidance I've read from the Department of Labor. So the specific criteria you would have to meet would be that you, if you granted the emergency paid sick leave or the emergency FMLA, your expenses would exceed your revenue and it would cause you to cease operations at a minimum capacity. The second one is that this employee holds such special skills or knowledge of your business that it would cause your business to endure substantial risk to its financial health. The third one is that there's not a sufficient number of workers available at the time and place where you need them to perform the labor and services that are being provided by this employee. So it's three pretty specific things that you'd have to meet and you'd have to document by an authorized officer in your business. Okay, so the other question that's come up is, can I run emergency paid sick leave or the emergency FMLA intermittently? Can you run it in, does it have to run all at once, or can you run it a little bit here and a little bit there? Well, it depends. We're not going to run emergency paid sick leave intermittently if someone's on a quarantine, right? Because we don't want them to come back and expose everyone. That makes no sense. You can run these leaves intermittently if it's for the school or child care issue. That would make sense and be a lot, I think, which is to try to get employees working as much as they can and be flexible with them to just get through this tough time together. So if you have an employee who has a child care daycare issue, but maybe their spouse is home in the evening and able to care for them, and they could come in and work part-time in the evening, you could run that intermittently, and maybe they're only on a part-time or reduced schedule then. Can I exclude any employees from these leaves? If your business would have emergency responders or healthcare providers, and those are defined in the Act, and they're defined somewhat broadly, then they're defined very broadly actually, then you could exclude those employees. But before you exclude anyone from a protected leave, you're gonna wanna talk to human resources or legal counsel about doing that. And so what do I do? This is the question that Amy and I get probably every day. Well, I have an employee that doesn't, they don't want to come to work right now, but they don't meet any of these criteria. They're just scared, or, for whatever reason, they don't want to work during this. Well, then you have to follow your normal paid leave or time off policies. The employees have to meet those criteria to get the emergency paid sick leave or the emergency FMLA. If they don't, then you got to follow the other policies. Otherwise, you're risking paying them this additional leave, and you're not going to get the tax benefit for it. Okay, with that, I'm going to turn it over to Amy to talk about some of the other protected leaves that may come into play.
Well, hello, everyone. I don't know if you can hear me or see me. I am still looking at Holly, but we'll soldier through nonetheless.
Amy, your screen flipped, I think.
What's that?
I think your screen flipped onto your desk.
How about now? Okay. Thank you. As you can tell, I'm older than Holly, and I don't do this as often. She promoted me as someone with broadcasting experience, but we sure weren't using iPads back when I did this. So good morning, Amy Reisner here. One of the things I would like to remind people is that Holly and I also run a small business. And so some of the issues that we're experiencing right now as attorneys are also applicable to us at our own law firm. And so it's been a unique situation to navigate not only with our clients, but our own employees. One of the things that is unusual in this circumstance is the Department of Labor continually is offering the guidance that employers and employees should be as cooperative as possible. And I think that's an important reminder here. People are very tense, they're agitated, panic is contagious. And so as leaders of businesses or as human resource specialists or generalists or attorneys, we have to remain calm and try to find solutions to these problems. And Congress certainly has provided us with some excellent tools here. It was a bit of a mess when we started off trying to navigate what they meant by these laws. I've never experienced having a law pass and immediately having to understand it within 24 hours and apply it before there's any regulatory guidance, but nonetheless, that's what we've done. And Congress actually used a lot of the framework that already exists under Family and Medical Leave Act and other types of civil rights acts. So for lawyers, it was pretty familiar. And we do want to talk about the FMLA because that didn't go away simply due to the change with this additional reason for the EFMLA, expanded or emergency FMLA. So if you're an employer that was eligible, and the eligibility is different here, and that didn't change. So you had to be an employer with 50 or more employees within a 75-mile radius of the primary workplace, 50 or more employees working 20 or more work weeks in the last year. That's the qualifier, and it remains the qualifier for FMLA. So if you weren't qualified last year for FMLA, you're very likely not now, but you may be for the expanded and emergency FMLA. So then you have to determine if you're an eligible business, whether your employee is eligible. And of course, that still goes back to the rule of the employee had to work for 12 months, 1,250 hours. Again, different than the emergency and expanded FMLA, which only requires the employee to have worked for 30 days for the employer. So could your employee be eligible under the FMLA because of COVID-19? The answer is yes. Serious health condition under FMLA is still defined as having an injury, an illness, or a condition that's either physical or mental, and that requires either inpatient treatment or continuing treatment care from a healthcare provider. And healthcare provider here is still defined narrowly. So it's not Joe Blow off of the street saying that the person is sick, or even the person saying, I have a serious health condition without a positive test, or without meeting that designation that the healthcare provider is going to certify that that's true and that they need continuing treatment. It also doesn't mean continuing treatment with over-the-counter medication. So you can see this is the same problem we always had with FMLA, is whether someone truly qualifies or not. If their doctor's certifying that they do and gives you sufficient information in order to ascertain that, then you do what you always did, which is you grant or approve the leave, and the person is allowed to take up to 12 weeks for their own serious health condition. Your employee would also be eligible if they have a spouse, a child, or a parent with a serious health condition. And again, that could be COVID-19. Again, the healthcare provider would have to certify it. But the other aspect is the person is, quote, required to care for that spouse, child, or parent. And we've always considered that to be relatively broad, and the regulations are broad as well, that if someone is needed at home to feed or comfort someone and the doctor is certifying it, we've generally said, that you should permit that certification. But in this case, you may want to consider whether you need to narrow that just a bit, just depending on the set of circumstances you're facing with your own business and your operational needs. As Holly already mentioned, no intermittent leave should be granted if it's COVID-19 related, whether it's the employee's serious health condition or they're at home with a spouse, child, or parent with COVID-19. Next slide, we're going to talk about the Americans with Disabilities Act. And I'm sorry, I should have paused. I didn't see any question, but are there questions regarding just normal FMLA in the pandemic? Okay, I don't hear any, and I don't see any. So we'll move on to Americans with Disabilities Act, which is the ADA. Everybody refers to it as that. But the Iowa Civil Rights Act also has a component for disability law as well. And they're pretty similar. The courts usually interpret them very similarly. So the question is, they're a person who's a qualified individual with a disability because of the pandemic is requiring a reasonable accommodation to enable them to perform the essential functions of their job. So I gave the example here of an employee with a chronic illness that is considered high risk by the CDC for potentially getting COVID-19 or becoming incredibly ill if they were exposed to COVID-19. So that chronic illness would have to be a disability under the ADA, That is a very broad definition, and usually will qualify even someone who is treating that chronic illness successfully could likely qualify under the ADA. So what we've recommended to a lot of employers in this set of circumstances is to have the employees who are concerned that they may be high risk per the CDC's guidelines communicate confidentially with your FMLA coordinator or your HR coordinator, who is the person responsible for managing medical issues in the workplace. We sent out emails that said something to the effect of, if you, employee, believe that you may have a chronic illness that's considered high risk by CDC, go to this webpage and look, then contact so-and-so confidentially by phone to discuss. Because we want to ensure that if the employee is concerned or the healthcare provider is concerned, that they not be working at the office or at a warehouse, that they make some accommodations for them if they can. The reasonable accommodation requirement is still the same. It has to be reasonable, and it has to enable them to perform their essential functions of their job. So what might that reasonable accommodation be? Could be someone, let's say, who's being treated for a severe case of diabetes or COPD or a health condition, which are all high-risk diseases per the CDC, and they want to work from home. If they can work from home and that's reasonable to accommodate them, then your duty under the ADA is to accommodate them. If they need personal protective gear, or they need to be isolated in your facility, or they need to work a different shift in your facility to effectuate the social distancing, those would all be reasonable accommodations. Finally, under the ADA and the Iowa Civil Rights Act for disability law, a leave of absence can be a reasonable accommodation. It doesn't require you to do that with pay, but you should analyze your own internal policies that existed before the pandemic to see what you would do about a reasonable accommodation leave. Could be unpaid, could be run concurrently with paid leave. So these are all things to consider if you have someone that alerts you with this set of circumstances. Any questions about this topic? And the last thing I would say about that topic is that right now it's very difficult for people potentially to obtain doctor's notes. And we probably should have said this, Holly, when we were talking about either EFMLA or emergency paid sick leave or any of these types of issues. So we're permitting employees to certify now and get the documentation later. And having them certify that it's true and accurate to the best of their knowledge is a good way to go. And we're allowing them to also do that by electronic signature. There are state and federal acts that permit electronic signatures. And then additionally, we're allowing electronic signatures from doctors. So if employees are doing teledoc or some sort of telemedicine and the doctor sends an email that has an e-signature, that is sufficient.
Okay. Are there any questions for Amy on those issues? Nope. Okay. So I just want to talk up a little bit about wage and hour issues and how those may affect your decision making during this pandemic. First, just to remind everyone, non-exempt or hourly employees, as we usually think of them, they need to be paid for all of their hours actually worked, even if those hours were not authorized. So if you don't already have this in your normal policies before the pandemic, that employees need approval before they would work any overtime, and if they would work overtime without approval, they'll be disciplined. I think that's something that I would update, especially if you're considering a work from home, which we're going to talk about in a little bit here. But these hourly employees, they have to be paid overtime for all their hours worked over 40, even if it's unauthorized. The question always is, what counts as all hours? What qualifies? All hours is any time that an employee is suffered or permitted to perform work on your behalf as the employer. So, there's always the issue, well, the employee took one call from me. Well, the court says that's okay. If there's occasional de minimis work off duty, you don't necessarily need to pay for that. That would be something less than 10 minutes. We're not talking about a half-hour call, and we're not talking about 10 10-minute calls or even 2 2-minute calls a night. We're talking about truly de minimis, truly a rare occurrence that this would happen. Then you would not need to pay for that. But otherwise, you'd want to err on the side of caution and count time worked under the all hours. So the question right now, I think on everyone's mind, depending on what industry you're in, is, can I reduce non-exempt employees' hours? And you can, unless you would have some sort of contract with that employee that guarantees them, X hours per week or per pay period, you could reduce their hours without any issue. They may be eligible for unemployment, and Amy's going to talk about those issues when she talks about furloughing, but you can do that legally. Okay, so now to talk about exempt employees. So starting January 1st of this year, they increased the amounts that exempt employees must make. So now they must make $35,568 annually, or $684 per week. And they have to meet certain criteria under the Fair Labor Standards Act also. I'm not even sure how many criteria. Amy might know exactly how many criteria there are, but there's several criteria where you can meet. Those are where you think about your administrative, your management type things. Those, they have to meet one of those. They can't just meet the income threshold. Generally exempt employees must receive their full salary in any week in which they perform work. However, they don't get overtime for any hours worked over 40 in those weeks. So the question, just practically, can I reduce exempt employees' hours? Yes, but if they work that week, I don't know why you would. It would make more sense to reduce hourly employees' hours and then allow that exempt employee to pick up, tasks to the extent that you can. Okay, so I'll turn it over to Amy to discuss furloughs and layoffs.
Thanks, Holly. So depending on the type of employee, as Holly was just talking about, you can furlough for varying durations due to a lack of work. So a furlough is often confusing, and actually the Cedar Rapids Gazette had contacted me, and I provided some information to James Lynch that was in an article, I think on Friday or Saturday, about this issue. A furlough is keeping the employees on your books as an employee. They're not separating. And you're changing basically their work schedule. So for hourly non-exempt employees, they could be furloughed for part of a work week. You could do days on, days off, or part of a work day, and they can still seek unemployment benefits. In this environment, you want to be sure that if you're doing that because of the pandemic, that your employees are clear. They need to say that they're still employed, but they're being reduced. And I've seen the form. There are places to check where they're being reduced, and they should say that it's due to a lack of work, and still note that this is because of the pandemic. So with unemployment right now, they can obtain 1 week on, 1 week off, or partial unemployment for even 1 week. Say you've been reduced by 35% for your hours, plus they're going to receive the federal benefit. One thing I want to note that has come up repeatedly is the issue of employees, and it's come up repeatedly, of employees who want to be laid off so that they could obtain the unemployment benefits. And I just throw this out there right now. I have urged, and I know Holly has as well, we don't encourage panic or fear to drive decisions in the workplace. So if you have work and the employees can do it safely per the CDC guidelines, social distancing, cleanliness, etc., then they really shouldn't be laid off. And if they try to quit and claim that this is due to the pandemic, then you should contest that. There's a box to check for protesting, and you can say, I've seen this already twice, this is not related to the pandemic, the person quit without good cause, or whatever the case may be. And I know this must have come up enough throughout the country because the federal unemployment officers have issued a letter that states very clearly if people try to quit and then claim pandemic unemployment benefits and it wasn't because of the pandemic, or they had work to perform and just refused to do it, that is considered fraud. And the employee would be facing repayment of the benefits, criminal prosecution, as well as being barred from making any benefit claim later. So when you're having these conversations with employees about just lay me off, etc., always start calmly. We have the work, we're doing the things that we should be in order to keep you safe. But if they're pressing you, you can indicate to them, look, we have work. So if you quit, it's a quit. It isn't because of the pandemic. So going back to the furlough issue, I was talking about unemployment. So hourly non-exempt employees can get partial unemployment plus the federal benefits right now. They could be furloughed for part of a work day, part of a work week. You could do one on, one off. You could do it for a block of time. That's number two. It could be 30 days. And the employee remains on the books. They're deemed your employee. You're not going to lose tenure for benefits calculation when they come back. And the employees should maintain their benefits with you. So health insurance is definitely an issue that should be continued. You need to work out with the employee how you're going to deal with that. So in the case of hourly non-exempt employees who have to pay part of their premium, if they're being furloughed and taking unemployment, that may be very difficult for them to have the amount withheld from their paycheck. So you may want to institute a plan where either they write you a check, however, that puts you in the bill collection business. So it may not be the best solution, but it's up to you. Or you can have it withdrawn from their checks, but you could make a different withdrawal schedule so that it's less, and then you have some period of catch up later. You just want to be sure that whatever agreement you use, that it's signed and dated by the employee, and that legal counsel looks at it to ensure that if you don't get paid, there's a mechanism for recovery later if you choose to do that, because there is specific language that's necessary under Iowa wage law for that purpose. So then also to salaried employees, Holly had mentioned this earlier, you can, an exempt employee, you can furlough them. The best way to do that obviously is on a weekly basis. So I work my regular work week, 1 week on, and then I'm furloughed 1 week off, and I can seek those unemployment benefits. So as Holly said, unless the employee is taking bona fide paid leave during a work week where they work, they must be paid for all of the work week. Salaried employees may run into some unique situations when they're applying for unemployment because of the amount of benefits that they may be seeking. And so I would encourage you, as we have done for other clients, to perhaps have HR sit with someone when you're first trying this and make sure that the employee has all the correct information that they need in order to make this claim. Okay, and so I've talked a little bit about this. I got ahead of my skis here on the withholding for benefits. So just remember that, you know, for example, right now, the Iowa Workforce Development is not penalizing employees if they took some of their vacation time in order to help them through a week while they're making a claim for unemployment, but they do have to notify unemployment that they took that money. It's probably preferable to just keep the leaves or paid time off on the books, so when they come back, they would earn them. But something to keep in mind, what if you can't recall them? And you either have to terminate them or there's a closure or what have you. If there's a closure, remember you need to talk to counsel about notices that may be required under state and federal law. But if you just can't recall someone that you furloughed because of economic reasons or workload reasons, if they're at will, you can terminate them. Under your policies, you may owe them for those benefits that are still sitting on the books. And of course, if they had health insurance, you need to make sure that they get their COBRA notice. But one of the things I'm thinking about is if you have a policy where when someone is terminated, they receive all accrued but unused vacation benefits, that should still happen if a termination occurs following a furlough. And as Holly mentioned earlier, if you have employees that are under a collective bargaining agreement or a union contract, you need to make sure that you follow all of those provisions. Oftentimes, there are provisions regarding layoff or recall rights, or if there's a separation, what benefits need to be paid. So don't forget about those contracts. Next slide. Thank you. A temporary layoff is a little bit different. It can be a separation of employment. So you would say, we're laying you off, you're terminated, cite a lack of work. So the employee ensures the right to the pandemic unemployment benefits. And then you can look at right to recall. Again, check your collective bargaining agreement, or if you have a policy in a handbook, you should follow the policy. You can always recall a person who's been laid off for a period of time if they're still available. Termination is a straight up separation of employment. There would be no discussion about a return to work or recall. Some of my clients have had that conversation with me pretty early on. If you were looking at separating certain people because of performance issues, or because of a slowdown that was occurring before the pandemic, this is not a bad time, and I'm not being callous, but it's not a bad time to start looking at those issues again. Remember that any group separation or termination should be done on non-discriminatory reasons. That is, you ensure if you are separating a number of people from a work unit or across the entire operation, you need to be sure that it's not happening where it doesn't disparately impact groups of people based upon gender, race, age, etc. So that would be a time when, again, you'd want to talk to counsel, or your HR should be involved so that you make sure that your workforce that previously looked like 70% 50 plus doesn't look like 70% 20-year-olds when you're done with that termination or layoff. I often suggest if there are performance issues that are the reason for furlough or layoff, that you make sure there was documentation of those issues before the pandemic. Otherwise, it starts to look like you're making it up now during the middle of a crisis. So now's not the time to announce that there's a performance issue when you never announced it before to employees. And often an easiest way to do a legitimate non-discriminatory layoff or termination would be LIFO, last in, first out. So I've seen some of my clients say, everyone who's been hired in the last 3 months, we're going to temporarily lay you off due to economic reasons. Any questions on furloughing, terminations, separations, temporary layoffs?
Amy, we do have one question, and it relates to the payroll protection plan. If you furlough employees, can you take advantage of that plan?
Well, let me take a look, because I have a cheat sheet on that. Again, trying to learn these areas. And there are some situations where you may not be able to make some of these claims if you are doing layoffs. And I believe the PPP, Paycheck Protection Program, has some markers for needing to retain your workforce. And so if you're looking at that plan, you want to make sure, whether it's that one or the emergency disaster loans, you want to talk to your banker, who is the qualified SBA loan officer, and determine what things you can't do, so that you, if you're going to take this type of a loan or a grant, that you aren't getting crossways and you don't get the benefits that you need. But I believe the PPP has some requirements of job retention that may be impacted here if you're furloughing or laying off.
Okay, thank you. And I have another question. For the IRS tax credit, should the employee portion of the qualified health plan expense be figured into the total maximum benefit? For an example, should the employee's premiums be considered in the total available benefit? $5,110 or $2,000?
Oh, for the emergency paid sick leave or EFMLA, is that what the question is?
Yes.
Okay, I will defer to Holly on that, but I believe it's just pay and not other benefits. But Holly, are you aware of that topic?
So that's how I understand the law also, Amy. I actually had never even thought of this, which tells me I've seen no guidance indicating that you, so far everything we know is just pay. But what I will say is the same thing I said at the outset. They're coming out with new guidance and regulations all the time. And I feel like especially on the IRS side of things, it's especially lagged. So that could change, that's what I understand right now, but it very well could change. And something could have come out last night that I haven't seen yet, because they have a great habit of putting things out at 7 p.m. or on the weekend, it seems. So that's what I understand right now.
And I would just add that I have been impressed with, they were a little slow to start, IRS, DOL, OSHA, but they've really sped up and started issuing guidance on a regular basis. And their guidance is pretty easy to read, generally speaking, even for lay people and someone like me who hates tax law. That's why we have tax lawyers. So you can always go to www.irs.gov and search for their publications. And they have, I believe, a tab on the pandemic and COVID-19.
Very good. Thank you.
So is this me, Holly, company time off policies? People get to listen to me some more.
Yep, it's all you till work from home.
Okay. So employers need policies regarding leave. And of course, if you have at-will employees, not collective bargaining agreement employees, your set of policies or handbook should have had a disclaimer before this that said that you could modify your policies at any time, even without advance notice. And this would be the exact reason why you need that type of disclaimer. So you may need to modify certain policies regarding leaves, especially kind of tying these all together either with the Emergency Paid Sick Leave Act or the Emergency and Expanded FMLA. But you also may need to modify some of the policies relating to just time off for people who are sick that aren't going to qualify under either your normal policy or the emergency type policies, but where we're kind of in that gray area where someone's symptomatic, they're exhibiting symptoms that may or may not be COVID-19, but their healthcare providers not getting them a test, for example. So we've been drafting policies that allow people to stay at home and use their sick time, even if they're really not sick at that point, but we're asking them to stay home. Some employers are even agreeing to pay regular pay for that. So I would want that documented in a policy, and it should be applied consistently. If anyone's ever seen Holly and I present anywhere, consistency is the name of the game when it comes to employment law. You treat similarly situated employees similarly. So similarly situated employees means if I've got a manufacturing plant here in Cedar Rapids and they've got 3 shifts and it's all the same positions and roughly all the same essential job functions, then those people need to be treated the same for policy purposes. Downtown, I've got my ops offices. Those people may be treated differently because they are in a different work unit and have different essential job functions. So just keep that in mind. Employers' policies should also state that the employer has the right to deny leave time because of business and operational needs. And this has come up quite a bit where we're talking about employees that may be mission critical. There's a lot of confusion out there because there's terms being thrown around constantly: emergency responders, law enforcement officers, essential job functions for, essential employees versus mission critical. If you're an employer that doesn't have those emergency responders or healthcare workers that are kind of critical right now in this emergency, you may still have some employees who are mission critical. You should define who that is. So here at Lynch Dallas, we defined that on or around March 17th. And that was the office manager, finance director, the HR manager, and our assistant bookkeeper / IT manager. Billing. So those are mission critical. We can't do without them. So what might that mean? Well, you should have a policy about who may not be granted leave off during the emergency. Now, I'm not saying if my office manager needs a day because she isn't feeling well, she's not going to get it. But I am saying that if my office manager announced, and she didn't, that she's terrified of coming to work or she doesn't want to work here anymore while the pandemic's going, I'm going to have a conversation with her about how she's mission critical, and we're not going to be, if she's not qualified for those emergency type leaves, we're not going to be granting a lengthy leave. Of course, management rights, whether we're talking about employers with union employees or non-union employees, management rights should always grant the employer the decision-making about what is a legitimate business need or what is an operational need. And so if that means that you're not granting vacations and personal days during the pandemic because you're running 3 lines at 24/7, again, document that, let people know that's what's happening. I've already talked about having that disclaimer, amending policies at any time without advance notice. But of course, again, there's the caveat for collective bargaining agreements. You're not allowed to amend a collective bargaining agreement unilaterally. You can work with your union employees and their bargaining representative to potentially obtain what's called a memorandum of understanding or a side letter if that's something that you need to do in order to suspend or modify certain leave policies at this time. Any questions on those topics? Okay, then we'll move on to the illness policies, and I'll be brief so that Holly can get to the remote work policies, which are really crucial. But there should be a policy on your books right now that talks about illness, travel, mass gatherings. It should have language that says, hey, employees, don't enter this building if XYZ, usually 100.4 fever, cough, chest tightness, etc. The policy should also indicate what happens if someone is traveling, going to a mass gathering. What's going to happen? Are they going to be sent home for 14 days? How are you going to handle that? Are you going to make them use their own paid time off? Are you going to share some of that time off? And everyone needs to be clear about to whom they report if they're symptomatic, a family member's symptomatic, but there's no diagnosis, or someone has been diagnosed, and again, that high risk category. You need to tie all of that together with the leave policies and make people clear on what entitlements they may have under the federal laws and your own policies. And you need to be clear when someone can return to work. So symptomatic but no diagnosis, if they had these symptoms, I believe the CDC's guidance is that they need to be 72 hours fever-free, no fever-reducing medications, and 7 days symptom-free. If they've been diagnosed, I think it's 14 days and the 72 hours, no fever, without fever-reducing medication. So all of that should be clear to your employees in a policy. Any questions? Okay, I'll turn it over to Holly on remote work.
Okay, we can just skip through that one too, Jill. Okay, so one thing I do want to touch on, because I don't know if it's been said yet, and I don't think it's covered in a slide. So when this started, right, it seems right around St. Patrick's Day that week is when this all sort of blew up. And then we heard, employer X is paying their employees, the employer X is paying their employees. Well, a lot of companies started that with the thought that this was going to be like 2 weeks, or a little bit of time. If that's where you went, the road you went down, and now you're looking at 6 to 7 weeks, and I think we're all sort of bracing for potentially longer than that. if you need to change that at this point, you can do that. And just be honest with them about what you need to do to maintain operations. I wouldn't want any employer to feel like they've went down this road and they're pigeonholed into something that's going to cause great hardship later on. So work from home agreements, you do need one. You can't just send, suppose you can just send employees home, and tell them good luck. But if you have an agreement, it's going to lay out the expectations, get everyone on the same page, which I think is the whole key to this, okay? The other key, I think, is even if we have this agreement in place, we're going to have to extend everyone a little grace. I feel very lucky that I'm able to work from home at this time. I don't downplay that at all. I'm, so lucky. But if you would have told me 2 months ago that I was going to work from home, I would have said, that sounds awesome. And in reality, I've got a 3-year-old and a 1-year-old screaming in the background a lot of the time. I'm giving a presentation in the middle of my kid's playroom right now. It's not as glamorous as I would have thought. So we have to extend everyone a little grace. These things, they aren't able to take the call, but they should be expected to call back promptly. Okay? So when you're drafting a work from home agreement, you want to have employees sign it. You want to outline the expectations. You want to give employees the opportunity to talk with you about questions they might have and to just, really get on the same page about this. You want to be clear that all your regular policies are enforced, and if they're not enforced, which ones? You're likely not going to enforce dress code on a daily basis unless they're on a video chat or something like we are now. Then you might have certain expectations like, please get out of your pajamas, something like that. Working hours and availability is so important, I think, to put those expectations in line, especially in this time where we have a lot of parents working from home trying to juggle their kids. So during waking hours, they may be with their kids, and then they're trying to get a lot of work done in the evening when maybe their spouse is home, if their spouse is an essential worker or hasn't been able to get off yet. So you want to just really set, if that employee is going to work, maybe a couple hours here during normal working hours and then work 4 to 10 at night, that's fine. But make sure everyone knows that, and we know when they're available and when they're expected to answer emails and answer phone calls. Workspace requirements. We want to make sure that their workspace is safe, right? Workers' compensation could still come into play. I think this could be very interesting, in a few months here, how that will play out, if that would be an issue. We want to make sure their workspace is secure, okay? If they have confidential documents, they should not be scattered about the living room table, although no one should be in their house at this point. The spouse, whatever, doesn't need to be reading those. We want to make sure, as I've said, we're going to extend grace. So we want to make sure that their workplace is as free from distractions as practicable. Okay. It's just not realistic that when someone's working from home, they're going to have the same exact productivity that they had in the workplace. They should still have good productivity, but I don't know that this is also the time to be really nitpicking, especially our good, steady employees, for what they are not able to accomplish at home. Equipment issues and concerns. You want to make sure that they have the equipment to do their job. Make sure you talk to them about that before they leave. I know some employers have delivered their office equipment to their home when necessary. You want to be very clear about expenses and compensation. So if you are going to reimburse them for use of their home internet, be clear about that at the outset. If you're not, be clear. If you're going to reimburse for part of their cell phone bill, be clear about that. There's not necessarily an obligation that you do that if you're asking for something more than what they have, or if if you're reimbursing some because they don't have it, you would want to look at the consistency aspect of that. But you just want to make sure that everyone's on the same page there. Any questions about work from home? Employees, which Amy's already touched on, so I won't spend a lot of time here, but I did outline what, as of Sunday, the CDC had listed for high-risk employees: those over 65, chronic lung disease, moderate to severe asthma. I'm not going to read down the whole list, but you can see them all there. If you, like Amy said, if you have an employee that has one of those issues, invite all of your employees to contact your FMLA coordinator so that they can address it, and then you can address it pursuant to the Americans with Disabilities Act. I think what keeps coming up for employers is, I know employee X is, getting treated for cancer right now, or I know employee Y has severe diabetes, and what should I do? I want to protect that employee. Well, if you send out your correspondence and you let that person know the options that they have, you would put that burden on them to come to you. The only time you would really want to go out and talk to them is if there was some sort of direct threat analysis under the ADA, and you're going to really want to talk to legal counsel before you do that. That's a kind of a windy road that can cause issues. So get in touch with legal counsel, and then you can address it that way. Okay. So I just listed off some of the questions that Amy and I have had over the past few weeks about, what to do with our employees. So I'm just going to work through those all with you. And I've taken a lot of my answers from the EEOC's guidance or the CCD. The EEOC is a really helpful page about what to, I forget what it is, but it's like basically EEOC guidance during a pandemic or something to that effect. So can I send an employee displaying symptoms home? Yes, you can. Amy already touched on that. If someone has that dry cough, if they're displaying shortness of breath, you can send them home as long as they meet those CDC guidelines for what the illness would be. You can't just send someone that doesn't, they look kind of pale. We're not going to send them home. They want to. What can I ask an employee who calls in sick? You can ask them if they have the symptoms of COVID-19. You cannot ask them if they have other symptoms, okay? So you don't want to get into, well, did you break your leg, or do you have some other, potential disability question? You just want to say, do you have shortness of breath, a dry cough, or a fever, the symptoms of COVID-19, and then move on. If they say no, leave it at that. We don't ask, well, then what do you have, just leave it. Can I take employees' temperatures before allowing them into the work site? Yes, you can. You want the data to be held by your confidential, the person who holds your confidential medical records, whether that's human resources or your FMLA coordinator. You can do this. I would say probably in the next 2 weeks, especially because we have so much essential manufacturing in Iowa. A lot of employers who aren't doing this are going to be doing this because it's a good way that we can kind of check things, and at least try to make sure our workforce is secure. Can I require an employee who traveled to stay off from work? If an employee traveled pursuant to the against what the CDC has specifically stated, which I believe is out of state, it's out of country travel at this point. I don't know that there's any country that you can really go to safely per the CDC guidelines. And then also cruises, which cruises are suspended. But if they'd be coming back, then you definitely could require that person to stay off. There's questions about out-of-state travel. The CDC guidance on their page last time I checked said the CDC doesn't usually comment on United States travel. They don't usually give any guidance on that. However, they have started to give guidance on that. Last I checked, it was New York and New Jersey, and potentially maybe California, but I don't remember. But I would look for that to grow. But I think the key to this is, as long as you are following what the CDC or the Iowa Department of Public Health says, that's going to be pretty safe. Even when I've looked at direct them back to the CDC, OSHA will direct back to the CDC or the local Department of Public Health, the state or local. So that's just important. Can I require employees to wash their hands? Yes. Can I require employees to wear PPE? Yes. Now there could be some issues with certain PPE if it would, cause some sort of issue with, I can think of like if there was a religious issue and they had a beard or something like that, that's going to be an analysis you're going to want to undertake with a lawyer. But don't get into a hard line of that you have to do this if they're raising, those sorts of civil rights protections. Make sure you talk to your lawyer and then follow up. Can I require employees to get a vaccine when one is available? No. That's where the EEOC says no, the line's drawn. Okay, so can I ask an employee if their child or spouse or relative tested positive? And how the guidance for this reads on the EEOC or CDC's website is that you can have a policy that requires your employees to tell you if someone has tested positive in their household, because that's how that would affect them. Or if someone they've been in close contact with, which close contact has become a term of art that changes definition. But last I checked, it was, I don't want to say it wrong, but I think it was 15 minutes or so with someone within a certain amount of feet. But you'd want to look at that. So you could write your policy if they've been in close contact or lived with someone who tests positive, they need to disclose that. I don't think we go around every day and ask every employee if their spouse, child, or relative has tested positive, because if they don't live with them, or they don't have close contact with them, it doesn't really even matter. Can I tell employees not to talk to the media or post on social media about workplace pandemic issues? So this is, we all wish we could, but we can't. We can tell employees not to talk about confidential medical conditions of other employees. We can tell employees, not to defame each other. But we can't tell employees not to talk about the terms and conditions of their employment. And if an employee is concerned about, an outbreak of coronavirus or COVID-19 in their workplace, and they're talking about that on Facebook, that's likely going to be protected activity under the National Labor Relations Act. And there's not going to be much we can do about that, or that we'd want to do about that. What I would do, with that employee, and what I have advised clients to do, is pull that employee in and have your human resource employee who has some soft skills and is, good at having conversations, sit down with them and talk about what they're actually concerned about. Why are you scared? Or, what could we, what are you critical of that we're doing here? And then have discussions about all the things you are doing and how you are compliant with the CDC recommendations, and move forward. And same with the discipline. If you can discipline an employee for talking to the media, it's going to be the same thing. If they talk about a confidential medical issue, like saying that employee X tested positive, then I think we talk about discipline under your policies. But if you were just talking about that, they're talking about the terms and conditions of their employment, I would again just pull in for those soft skills. You also are going to want to look at, if you have a social media policy, you're going to want to make sure you follow that, right? We're not going to, if our social media policy, says that employees, can discuss or can say whatever they want about the company, then we're not, even if we think what they've said is defamatory, we're not going to discipline them for that now. We need to have a discussion. You need to make sure those policies are updated and appropriate and in place, because if this does, from what I have followed online and what Amy's followed, just for our clients, if this gets into your workplace, it's going to be reported most likely, and comments. So having everyone on the same page at the outset, I think, will be helpful now.
And Holly, I would just add on that social media policy, this would not be a policy that I would start amending now after someone has talked to the media. Right. Because if you really want some sort of action through the National Labor Relations Board, or through Iowa's Public Employers Relations Board, that's the way to do it. Creating a new policy or amending your policy after someone has spoken to the media.
Right, we would want to do it before. Okay, so what's going to happen if someone tests positive? That's kind of the next step that I think every employer needs to think of if they haven't already had to think about it. First and foremost, you're going to have communication with that employee. Something that I forget, because I'm a very, task, and I want to take care of things. Check in on that employee. Make sure they're doing okay. They're probably scared out of their mind. So you want to have communication with them and see if there's anything you can do as their employer at that point. internally, you want to have your communication chain established now. These test results come in at all hours of the day. They don't just come in during business hours. So if you run a 24-hour operation and your overnight manager takes a positive test, takes confirmation of a positive test from an employee, that person needs to know what to do with that information. And the answer isn't going to be that we let 10 employees know this has happened and freak everyone working the overnight out. The answer is going to be that we move it up to HR and whoever needs to know from there. You want to have a designated person that communicates with the employee and just determines close contact. If you don't know what close contact is, or you don't feel comfortable with that after making that definition, you want to contact the specifics about the employee and their confidential medical information. I think practically, most likely, if there's a positive test, the Iowa Department of Public Health is going to be in contact with you. That's how we've seen that working. However, as we have more positive tests, Lynn County or whatever county you may be in, and the Iowa Department of Public Health are going to become more burdened, and you may need to start that close contact analysis on your own. Okay. So then we're going to move into communication with other employees, because they're all going to be freaked out, just inevitably. When you know who has close contact, whether you make the analysis based on what guidance you have from the CDC about close contact, or the Iowa Department of Public Health or Lynn County's made that analysis, you're going to communicate with those employees that they've been in close contact and what they need to do regarding quarantine. You're not going to still divulge who they were in close contact with. We're going to keep confidential medical. Have a communication with your other employees who did not have close contact, that there's been a positive, that you're working with the local public health authorities, you're following all CDC guidance, you can't answer any confidential medical information. So this is just where we're at. When you're dealing with the close contact, something that I just skipped over here that I think is important, that I was reading over the weekend. When you're talking with those close contact employees, they're going to ask, well, what do I need to do? Well, we don't know, because you're human resources, or you're a business owner, or you're in whatever role, and you're not a doctor. So you're going to direct them to their doctor or the Iowa Department of Public Health, and let them know that they need to tell them that they've been in close contact with someone with a positive. Now, we all know the healthcare system's overwhelmed. So if you want to tell them to self-isolate or not be at work, that's completely reasonable and probably best practice until they're able to work through that with their healthcare provider or public health. But that's where they would be at for you all. You want to check in on those employees again. You're going to want to do cleaning of your facilities as recommended by the CDC or the Iowa Department of Public Health. And then group messaging, as I talked about, especially if you're going to have a temporary shutdown or cleaning, you're going to want to make sure that you're messaging that and communicating. I think, just in my experience in watching this unfold other places and watching it unfold at our own business, the more communication you have, the less people panic. So the more you can tell them without, you don't divulge anything confidential, but the more you can tell them about what you're doing to manage this situation, the better off everyone's going to feel. Okay. I'll turn it over to Amy now.
One last point on that, Holly, is that when those employees contact you, if they have a coworker that tested positive, they're going to want to know, again, the leave issue. Do I qualify for paid time off, et cetera. So having those policies already set and being able to communicate them right at the moment where the person is upset and confused is going to be calming, as opposed to having to say, I don't know, I'll get back to you, which will just throw them into a deeper fear of losing their job or losing pay, et cetera. One of the things that Holly and I have talked about with some of our clients is being sure that when the media or community members or clients or vendors contact you, that you're saying the same thing and it's not more than what you told your employees, because that's a good way to breach trust with your employees. So we just reiterated over and over through these slides, have that communication chain established now. You don't want vendor X to call his favorite salesperson Y and get the messaging. There should be clear channels that 1 or 2 people have the message and they're going to disseminate it. And if there are important vendors or clients, you may want to be proactive about that so that they're not coming to you. Again, that may feel like a breach of trust to them if they find it out through the media. Prepare a template message now. Certainly, Holly and I have already had an experience where there was a presumptive COVID-19 and everyone was saying, well, we need to shut this whole place down because there's a presumptive COVID-19, which I don't think ever actually turned into a positive. And that's back to a leader needs to lead at that moment. You can't let panic overtake the workplace, and we can't operate on rumors or fears. So we have to follow what the CDC and the Iowa Department of Public Health says. Be ready for that message. If it's a presumptive and the person was asymptomatic, you may have a different message than if it's presumptive and the person's symptomatic. And then you need to be prepared what you're going to say if it is a positive test. So if you have a larger workplace, or, I'm not picking on them, but General Mills, I think, had a case already. We've already seen that in the news. I don't know how that got to the news, but I would suspect it probably was someone on the workforce reporting it, which, again, they have the right to do. But you don't want to be scrambling around and trying to communicate with the media when they're under a deadline, because oftentimes, as we know, they'll go ahead and just print or say whatever they think without you ever having managed that message. So being prepared, it seems like it's silly now. Why should I prep a message like this if I don't have the situation? The likelihood, as we understand from the peak concept with this virus, is that you're going to. So be ready for it. And I think that's all that we had. We've left some time at the end for questions. I've got about close to 10:15 in the morning, and I think we're booked until 10:30. So if there's anyone that has questions about the material that we presented on, we're happy to take those. Or if you have other questions, we'll certainly tackle those. But as Holly said at the outset, please don't be offended if we don't know the answer. We may not. I have Jill's seen this already, but I have a stack of materials and spreadsheets and outlines, and we're still learning this as well. But if you have a question we can't answer, we're very willing to respond to you privately once we have it.
Are there any other questions out there? I'm not seeing any roll in. Just as a reminder, you can use the chat feature that's at the bottom of your screen. Okay, well, I'm not seeing any remaining questions. Amy and Holly, thank you very much for the excellent and timely employment law information. The Marion Chamber of Commerce appreciates your partnership in getting this valuable information into the hands of our members. We will be sending out the slides that you viewed today, and in addition, Lynch Dallas has provided some additional resources that we will be passing along to you as well. Thank you all for joining us today. Tomorrow, we will be hosting another virtual meeting with the Marion Public Library Director, who's going to walk us through a lot of the online training tools that are available free of charge if you hold a library card at the Marion Public Library. That meeting will take place at 9 a.m. and you can sign up for that at the Marion Chamber website under the events tab, just like you signed up for today. With that said, I think that kind of wraps us up for today. Again, Holly and Amy, thank you so much.
Thank you, Jill.
You bet. Everybody have a good day.
You too.
Thanks.
Bye-bye.
Bye-bye.